Hello everyone and welcome to Uncivil Law. For today's video, we turn our attention to an op-ed interview that was conducted by Supreme Court Justice Stephen Breyer, who stepped down some time ago, and has sounded a new warning in a new book saying current Supreme Court very bad. So this is a person who served on the Supreme Court for a whole number of years and stepped down, and I was thankful when he did. Mr. Breyer, Justice Breyer, had a style of questioning that drove me a little bit batty. He would give these very long-winding questions. They weren't very tight and just would go on and on sometimes. It's like, could you just stop asking the question, please? Any time would be fine if you could just stop asking the question so someone could give an answer. So he had these long-winding hypotheticals that were a little unwieldy. And his decisional style, his opinional style, was one of, in my view, and different people characterize it differently, where it was just an interesting balance. It was an interest balancing test. So he would weigh things in a sort of scale way, but he didn't seem to have many absolute principles, as far as I could tell. Right, everything was just on the scale to be weighed. There were not really many absolutes. There were not really any firm line rules in his mind, or it seemed to be. It would just do this mealy mouth balancing test all the time. Everything was in balance. So rights were important, very important indeed, perhaps, but not so important that they couldn't be balanced out by other things. Whereas that's not how really we just do it in a weighing exercise, typically in modern Supreme Court world. So anyways, Justice Breyer has written a book and he's given an interview to Politico, and we're going to read this and critique his critique of the current Supreme Court because, you know, well, I disagree with him and I want to. So this is an op-ed in Politico that is entitled "A Supreme Court Justice Sounds a Warning." The former Supreme Court Justice Stephen Breyer says in a new book in an interview that conservative justice's approach can't serve the country and it is doomed to fail. Okay, I mean, the conservative justice's approach is essentially my approach, so I suppose he's saying that my approach also is doomed to fail. I'm sure he'll inform me why. Okay. And this article/interview was apparently conducted by Akush Karidor, who is a former federal prosecutor who served in white crime, who writes the following. When Justice Stephen Breyer stepped down from the Supreme Court in 2022, he left a court with a record of accomplishment, but a legal approach that had been battered. Yeah, I mean, that is correct. The current court is not really interested in his approach, where it's just sort of just pure weighing of things with no real anchoring things in sight. It just seemed to be throwing everything into a hopper and sort of asking the question, well, what's in the best interests of the people versus like, what are the legal principles? It was outcome determinative, or it was looking in a utilitarian fashion, maybe is the better way to frame it. You know, whatever is the most good. So we don't really care about fundamental rights to the extent that they're outbalanced by other things, in a non-principled way, as far as I could tell. So yes, we've sort of abandoned that approach. With former President Donald Trump's 3 appointees on the bench, the court was firmly in the hand of the conservative justices whose theories of constitutional and statutory interpretation differ fundamentally from that of Breyer. I would agree. Their methods have already upended American law in recent years in a variety of areas, including most notably abortion, a subject to which the court will return on Tuesday when it bears arguments over the availability of the abortion pill mifepristone, which we've covered that oral argument. And my working bet is that the Supreme Court is going to uphold what the FDA did because of legal reasons that we discussed during the oral argument, right? The conservatives actually have legal principles, to my mind. So their personal thoughts on abortion are sort of neither here nor there. They overruled Roe versus Wade because it was untenable at law. It had been widely criticized by even progressives and members of the left as being completely unmoored. Because where in the Constitution do you come up with the right to an abortion? And even if somehow you can get a right to an abortion out of the Constitution. Roe versus Wade set up a trimester framework. Roe versus Wade said, abortion is okay in the first trimester, can be regulated in the second trimester, and can be forbidden in the third trimester. I challenge you with every possible tool at your disposal. How the hell do you come up with that trimester framework out of the Constitution, assuming you can find a right to an abortion in the first place? It is completely unmoored from anything. They tried to cobble together a whole bunch of constitutional rights and say it speaks to some broader sense of privacy, but it doesn't really work. Now, in the case of the abortion pill, the conservative justices seem to be looking at it legally. That was the questions they seem to be asking. And we're looking at something like an 8-to-1 reversal right now because the people who are challenging the pill won below. And we're looking at an 8-to-1 reversal. That's what people are sort of predicting. And I think that's probably right, if not 9-0. So, you know, well, yeah. So I think the FDA is going to win the day. I think the abortion pill is going to remain on the market because of legal reasons. And so, you know, that's how that rolls. In a new book that comes out the day of the argument and an interview with Politico, Breyer has hit hard the approach of the conservative former colleagues and sounds an alarm. I think technically correct is the best kind of correct. He technically remains a colleague because he retired, didn't resign. So it is technically correct is the best kind of correct to say he's currently a member of the Supreme Court. It's weird, but yeah. Anyways, if the court continues to deploy their methods of interpretation, Breyer told me, Politico, we will have a constitution no one wants. It's a remarkable statement from the former justice. Well, if it's a constitution no one wants, then perhaps we could change it. And there's a mechanism for that in the Constitution, the way to amend the Constitution. If it's truly a constitution no one wants, then we can change it. We're not stuck with it, but you have to actually go through a process to change it. You have to go through an amendment process, which we've done 27 times before. We could keep going. If people are not happy, you know, you just have to get, you know, a sharp enough consensus to change things on a fundamental level. That's the whole point. You need essentially a supermajority of the country to agree to it because it's a foundational document. So, you know, if everyone hates it, then everyone would agree to replace it. So you should be all set. The conflict between the left and the right is virtually impossible to bridge. Yeah. Conservative justices broadly favor a constitutional interpretation known as Originalism, which purports to interpret the Constitution in accordance with public meaning of the text when enacted, and a theory of textual interpretation known as Textualism, which prioritizes text over considerations like congressional purpose and practical consequences when interpreting laws passed by Congress. That is broadly correct, although I would personally not agree that textualism is separated in this way, although other justices might. And it's a little bit of a nomenclature problem because people don't necessarily use the words in exactly the same way. So I think that there's a dividing line, or at least textualism is perhaps a more specific version of originalism, maybe is the best way to think about it, but I wouldn't split it on statutory versus constitutional interpretation. I wouldn't split it that way. To me, interpreting the Constitution is no different than interpreting a statute or interpreting a regulation. Now, the Constitution, of course, says that it's the primary law. It says it's the supreme law of the land. So the Constitution beats a statute, and a statute beats a regulation, because the regulation depends on the statute for its authority. The statute depends on the Constitution for its authority. But I wouldn't sort of change like how I interpret one versus the other. I'd use the exact same tools. So I'd interpret the Constitution using the exact same tools I'd use interpreting a statute and a regulation. And then if there's a conflict between them, I know how to resolve that conflict because I know what beats what. So I wouldn't necessarily agree to this framing, but whatever. But yes, originalism focuses, well, I would say textualism focuses on the original public meaning of the text. I'd say that's what textualism is. That is the thing, because in an interpretative guidance, there's a couple different ways to interpret a law. There's a couple different master tools we use. And we've discussed this before. So we can talk about the intent, we can talk about the purpose, we can talk about the text, we can talk about the history, we can talk about public policy. So these are some of the tools that we use. So an originalist, broadly speaking, is going to look at the text and the original and the history of it and a little bit of the purpose behind it. And they're going to discount, especially, policy. Now, a textualist is going to lean really heavy on text, whereas an originalist might hold some of these other ideas in more of a balance. A textualist kind of rejects the balance in favor of a strongly weighted textualist approach, which is more my favorite flavor at the moment. And the way to distinguish this, to my mind, was best illuminated in the case dealing with the issue of transgender people in the workplace. And this was the dispute in the case as it relates to Gorsuch, who wrote what I'd consider to be a textualist approach, versus Kavanaugh and Alito, who wrote what you might consider to be more of an originalist approach, more of an approach that probably Scalia would have agreed with. So you see this sort of divide among the conservatives in this way. And personally, I thought Justice Gorsuch's reading was much more persuasive. So I'm like, well, okay, I guess I favor more of a textualist approach. Now, I don't know necessarily I go as hard as Justice Gorsuch would, but it convinced me to re-weigh these factors for a more text-heavy approach, as opposed to looking to these other considerations. The idea, by the way, in principle, being that the words are the most reliable thing, because they're the thing that everyone agreed to. You know, some of these other things that can be teased out are a little bit more problematic. They're a little bit more subjective. The text is the most objective thing you can have, because it's literally the words on the page. It's hard to get much more objective than that, as opposed to some discussion of history, or some discussion of purpose, or some discussion of intent, or some discussion of policy, which is more, well, it's less definitive. It's not just, I can read. So I can read has a pretty strong appeal to it. So that's what I would say, and sort of how you look at it. Liberal justices like Breyer had long embraced theories which are flexible in nature, allowing judges to account for a variety of inputs when answering legal questions. That's true. Justice Breyer, as I said, sort of at the intro, favored the way I'd characterize it is sort of all the interests go into a hopper. And, you know, your First Amendment rights or Second Amendment rights or whatever right it is may be good, but it can just sort of be outweighed by other considerations in a way that the conservatives would not do that. The conservatives have their own tests, but they're less loosey-goosey. So I'd agree with the characterization broadly. For Breyer, the problem with the conservative approach goes beyond the desirability on specific outcomes like abortion, affirmative action, or executive power, an area which the conservative majority has already significantly changed the constitutional law. I would argue in more of obedience of what the constitutional law is. That would be my argument, because I think they're interpreting the Constitution, what it says. So, yeah. Breyer argues the conservative theories are inherently fraught, regressive, and anti-democratic, and just as prone to mischief and misuse as more flexible and expansive theories that the conservatives reject. Well, on one front, he's correct. They are anti-democratic, because that was the point of the Constitution. The Constitution is anti-democratic by its nature, because it is designed to take certain decisions just out of the normal considerations of the normal legislature doing their normal legislative thing. That was the point. That was the point. It was to make certain things beyond just normal political considerations. It was designed very specifically to prevent democracy and even the republic form of democracy that we use. It was designed to prevent the people and their elected representatives from doing certain things. That was the idea. It was an idea that there were certain principles that were so important that the people shouldn't just be allowed to vote to repeal them on essentially a whim, like they might do any other legislation. You know, should the road have a speed limit of 35 or 45? I don't know. But, you know, the people could presumably vote to change that on essentially a whim. We think 35. Now we think 45. Now we think 35. Right? They can change it on a whim as they decide. And any other number of legislative things that exist. Taxing authority. How much should tax be? What kind of taxes should we have? What kind of regulations should we have over the air or water or, you know, the stock market? Those essentially can be changed on a whim. You have to go through the legislative process, but if you can do it, you can do it. They can just be changed like that. The whole point of the Constitution was to make certain things anti-democratic in sort of denying the people the right to just vote on it. We don't want the two wolves and a sheep voting on what to have for dinner. That was the idea. Now, in terms of regressive, again, yes, that was sort of the point. These were principles that our founding fathers thought were so important that they should stand the test of time. Again, it was meant to lock things into place and make it really hard to unlock the things into place. Not impossible, but really difficult. Yes, it's regressive in sort of, yes, we're all working on 1780s view of what the fundamental law should be. The people today probably would not vote for the same fundamental law, which is one of the reasons, incidentally, I get a little bit nervous when some of my conservative friends start talking about having the states directly start trying to draft constitutional amendments, a convention of states. I get very nervous when they talk about this because, well, we've never done it before and we don't know what it's like. And I don't have a lot of confidence that we go into a convention of states and don't come out with total disaster. Because I don't think that the people would vote for certain fundamental principles the same way they did today. So I'm very concerned. But that was the idea, to make certain fundamental principles fundamental, etched into stone, as it were. So Breyer says that they're regressive and anti-democratic, like that's a bad thing, when it was, in fact, the point. To deny the legislature, to deny the executive, to deny the judicial, to deny the states, to deny the federal government, to deny the United States and its corporate parts or its separate parts, the power to do stuff. So the very thing he thinks is the problem is the feature. It's not a bug, it's literally a feature. That's what it was supposed to do. So, you know. He says, if you think the approach is going to be simpler, I have a bridge in New York I'd like to sell you. Well, I don't think simple was necessarily the goal, but I think it's a little bit simpler. Now, it still is complicated, but it is a little simple. So I won't go so far as to say it's simple, but it's less complicated, in my humble opinion. Because now we're just trying to determine what something means, as opposed to trying to determine what, you know, sort of in some sort of modern collective balance is judged wise. Maybe that Fourth Amendment protection isn't that important anymore. Maybe that Second or First Amendment protection isn't that important anymore. Because, you know, of reasons. As opposed to, no, these are fixed stars in our guidance. So I think it's a little bit simpler. But even if it weren't simpler, that wouldn't be the point. The point wasn't to make it simple, although I think it does that. The point was to do what the Constitution commands. The Constitution says it's the supreme law of the land. The Constitution provides a process for amending the Constitution. So if we take that seriously, which I do, then we're just trying to figure out what that says. Just the same way, incidentally, that a statute passed by Congress or a regulation passed by the regulators, we'd be doing the exact same thing as far as I'm concerned. Just trying to figure out, what does it say? What does it mean? Literally, what does it mean when it was written? So that is a slightly different approach, but being simple wasn't the point. The point was to do what the Constitution commands, because every justice takes an oath to the Constitution, just like every federal officer does, and every state officer, for that matter, takes an oath to the Constitution. So, you know, if you really believe in your oath, if you really believe in the fidelity to the thing, and the thing says, hey, I'm the supreme law, and if you want to change me, here's a way to do it, unless you do that, then it hasn't changed. So you must do what the Constitution commands, because it hasn't changed. So simplicity was not the goal. So yeah, and I don't think it's I certainly don't think it's more complex than Breyer's approach. So I don't know what he's talking about 100% on that one. We talked at length over these and other issues, including the still outgoing fallout from the court's decision over Roe versus Wade. The court seriously diminished public standing. The media isn't helping, by the way. And whether American democracy is in crisis. No, American democracy is perfectly fine. It's doing exactly what it's supposed to do. Let's read the interview. Question. Your book provides a sustained critique of originalism and textualism. Maybe I should get the book and just critique the shit out of it. Maybe I'll buy the book and just critique the absolute shit out of it. That'd be fun for a series of videos. So maybe we'll do that. Your book provides a sustained critique of originalism and textualism, which now seems to be the prevailing methods of constitutional and statutory interpretation on the court. You warn these methods will not help achieve the goals of those who write statutes or those who wrote and adopted the Constitution. Who'd you write the book for? I wrote the book for lawyers who are interested and people who aren't lawyers. Lots of people, if you read the papers, think the court is reaching decisions they don't like. Others do like them, but many do not, which could be said of the court before, incidentally. This isn't really supposed to be a popular vote kind of thing. And then they blame politics and say the court is political. That is not my view, which is good, because I don't think the court is political either. Perhaps their candidacy was supported by people who have political views, but what they were supporting was the nomination and election or appointment of judges who would think this is the right way to go about deciding constitutional or statutory case. And the right way to become has been more and more of a kind of literalism, a kind of textualism, a kind of originalism. I think that's right. And I think Justice Breyer is correct to note it's not political, because I don't think it's political because of the reasons I just stated, right? The Republicans, or stated earlier at least, a Republican legislature would probably vote to remove the abortion pill, because that would be consistent with Republican thinking. But a conservative justice doesn't do that, because that's not what they're there to do. They're not there to just enact policy or further policy. In fact, the conservatives, what can be said for them is that they pretty much eschew policy as one of the tools. So while it's a tool the liberals will use and perhaps lean on even dominantly, the conservatives pretty much think it's garbage, because they think that the political branches are the ones that do policy, not the courts. So, yeah, and I think that's right. And that's what it is. It's not that they're voting, it's not that the judges are voting Republican or Democrat. That's not what they're doing. And again, you can see that by sort of Justice Gorsuch, for example, in his opinion in Bostock, the gays in the workplace case. Not a lot of Republicans super duper thrilled in first principle about that issue, but he was viewing it from a legal principle. And there's any number of other examples, by the way, that you could go to. So, yeah, I mean, that's what they're doing. And it's kind of a literalism because, well, that's what the text says. The text says, do this. So it's like, yes, we're going to take it literally because that's what they wrote. And that's probably what they meant. So, draft your legislation to say what you mean, I guess, is a pretty good tip. Justice Scalia said that consisted of looking a meaning in the text, ascribe to the text the meaning it had borne from its inception, and reject judicial speculation about the drafter's extra-textual derived purposes, the desirability of fair reasoning, the anticipated consequences. In other words, don't look at the consequences, don't look at purpose, look at text. Which is sort of how I think just generally. I tend to think in policy and procedures, not outcome. I tend to look towards the rule. Follow the rule. And the rule will get you to the place you want to be, hopefully. But follow the rule. As opposed to, here's what I want to have happen. Here is the best outcome. Here is what I want to have happen. So let me skew or change my rules to get me to where the place I want to be. You know, I'm very flexible. You know, so rather than have a singularized matrix that just works like a flow chart, as you were, right? I just have a bunch of rules that exist in some sort of grab bag, and I'll just grab whatever rule gets me to the right result. But you don't apply the rules in a consistent way. That's the problem. You know, you just use the rule when it helps you, and you don't use the rule when it doesn't help you. So you use the rule, which is a valid rule in and of itself, but you misuse it. You misuse the tool. Because you don't use it when you don't want to, even when you should. And you use it even when you shouldn't. You have misused the tool. As opposed to the conservative approach, where it's like, well, I'm just going to use the tool, and whatever happens, happens. So, yes, that is essentially the correct text. The correct idea. Don't look to the consequences, don't look at purpose, just look at text. That's essentially correct. Now, that's a very seductive theory. I tend to think so. Why? Because it makes two important promises. Promise one is the job, even in the Supreme Court, will be simpler, and there will be a single answer. Again, I wouldn't say necessarily, well, it'll be a little bit simpler, but I'd say it will be correct, hopefully, if we're applying our principles. It'll be true to what we're trying to do. Second, the promise is that the judges will not be able to substitute or less able to substitute their own views of what's good for law. I agree, and I think we can see examples of that in the conservative bench. It's not just a hypothetical. I'm trying in this book to show the reader something. I'm not writing as a professor. I'm not writing as an academic or a scholar. I'm writing as a practicing judge, and I've had different experience than they've had. I want to show them what it's like to try to interpret the words in the Constitution or in the statutes according to either the textualist theory, or we just look at the words, or a more traditional method. Again, by traditional, he means the one that the left, more leaning part of the court had been using for like 50 years or so, is what he means by traditional in that sense. The more traditional meaning being, the more traditional method, yes, start off with the words. If the word in the statute is carrot, that doesn't mean fish. Be fish disapproves. But go on. Why did someone write those words? What was the purpose? What are the consequences of a proposed interpretation? Will they further the purpose? And the values consistent with that value that were written, democracy, human rights, into our own Constitution. Which means that carrot might mean fish. If that would further the purpose, presumably. Be fish more approves of this idea. As you mentioned, the very promise of originalism is very seductive. I tend to think so. It offers the appearance of democratically legitimate, empirically grounded method for answering hard constitutional observations. That's what it's supposed to do. The people in their collective wisdom created the Constitution, and the Constitution allows the creation of statutes, and the statutes allow the creation of regulations, and the people through their collective power have created a hierarchy which has to be enforced, and it is somewhat more empirical. That is sort of the idea. If we're trying to figure out what a constitutional provision means, why not consult the people who wrote it and the people who were affected by it at the time? That would be a good idea, because then we have a pretty good idea what they were talking about if we consult what they thought when they were writing it. That'd be good. What was the meaning of, what was the understanding of this thing? You have a very stark warning to people who may be drawn to this nation. You describe originalism as inherently regressive, writing that will not permit modern solutions to modern problems, and consigns us to the set of views and values that predominated during the period when many groups of people today were not equal citizens. Yes, that's true, and also the point. Yes. It doesn't permit modern solutions to modern problems in so much as those modern solutions defy the constitutional text, which was the point. That was the point. To prevent certain solutions to certain problems. Although, incidentally, I would challenge the idea that these are modern solutions to modern problems. I don't really think that's true. These are old solutions to old problems, perhaps in a new context, but it's the same thing as it was before. This is, I don't really think that there's much new in law in a lot of ways. There's new applications, to be sure, but it's kind of the same thing that happened before, just happening again in a slightly new context with slightly new technology, or perhaps much different technology, depending on your point of view. But the problem on a sort of fundamental level is the same problem you were having before. You want to do a thing, whatever it is, for just the bestest of reasons, don't you know? And you're not allowed to do the thing because the Constitution says you can't do the thing, which was the point. So it's like, does he not understand what the point of the Constitution is? I guess he doesn't. It seems to me that the point of the American Constitution was to fix certain fundamental truths into stone, which can be changed by, the stone-making process. But it wasn't meant to be easy. As to certain people not being citizens, that's true. That's why we amended the Constitution, because that was dumb. And we recognized it was dumb. So that's why, hence the 13th, 14th, and 15th Amendments, for example, and the 19th Amendment, and the 26th Amendment, for starters. That's why we passed those amendments, at least in part, because we recognized, hey, we're depriving people of being people, and that seems really dumb. But we went through the process to do that, which is what you're supposed to do. When the founders were thinking and writing the words of the Constitution and protecting certain basic rights in the Constitution, women were really not part of the political process. They didn't have the right to vote, and there was slavery, and slaves weren't part of the political process. You're correct. We solved these problems quite a while ago. Please consult the 13th, 14th, 15th, 19th, and 26th Amendments for reference. In 1860s, after the Civil War, they wrote words designed to protect some people, but the theory of who was part of the community, America, which proceeds through democratic means, were quite different than it is now. That's true. We've brought out the sense of what the community is by amending the thing. And to say what happened then, what people thought then, what the reasonable person thought, what those words meant, well, that will overlook a lot of changes designed to further value the protection of basic civil rights because the world has changed. But so is the Constitution. So I'm not really sure what you're talking about, to be quite honest. I'm not sure what people you'd think are not part of the political process that should be. In this point, I don't really know what you're talking about. I don't quite get that. Is textualism just the same as civil Roman common law? No, I wouldn't say that. No, not in my view. You could have a textualist, originalist approach in either system of law, I think. I'm not a civil law expert, but I can't think of a reason why you wouldn't be able to. So textualism and originalism, the interpretive modes supersede they supersede the distinction between civil and common law. I can't think of any obvious reason that you can't use any of the tools that you would use in common law, also in civil law. So I don't think that's the correct distinction, but thank you for the question. And as to the idea about we can't amend the Constitution anymore, I don't think that's true. It's just that we don't have a robust consensus, which was the entire idea. I can imagine a number of circumstances which would cause the people to become broadly aligned in any number of circumstances. But the whole point was to make sure that the people were broadly aligned. So I'm not sure that I agree the Constitution can't be amended anymore. You just have to find something that, you know, everyone agrees on, which, you know, if the need is sufficient, then you're there. That was the idea. Was the 19th Amendment really necessary given the interpretation of the 14th Amendment Equal Protection Clause? The Supreme Court said so, incidentally, because they were asked exactly that question. The Supreme Court was asked whether or not the 14th Amendment gave women the right to vote, and the Supreme Court said no. So that's why they created the 19th Amendment. So, yeah, the Supreme Court was asked that exact question. The Supreme Court said no. So then they created the 19th Amendment. So there you go. In the 1860s, after the Civil War, they wrote words designed to protect some people. Well, no, really not. I mean, the whole point was to kind of protect everybody. But the theory of who's part of the community is quite different than now. I don't really think that's true. After the Civil War, I'm not sure that's true. What is the distinct? Well, I mean, I guess women got the vote in 1919, so I guess there's that. But, and 18-year-olds got the vote in whenever that was, whenever the 26th Amendment got ratified in the 70s, I think. But, yeah. And to say what happened then, what people went through, what the reasonable person thought the words meant then, will overlook a lot of changes designed to further the protecting basic civil rights because the world has changed. Again, if you think this is a fundamental basic civil right, first of all, you can do it by statute. You can create rights by statute. So you don't need a constitutional amendment. You can just create rights by statute, and Congress does, and the legislatures do of various states. You can just create more rights. So first of all, you can just do it by statute anytime. And second of all, if you want to put it in the Constitution because it's so important, then, you know, you have to go through the thing. But I don't really know what you're talking about when you say there are basic civil rights that aren't protected. I'm not quite sure what you had in mind here. But, okay. We used to have good arguments in front of students a lot, Scalia and I, and we were good friends. They saw we liked each other. I'd say, Nino, the world has changed. George Washington didn't know about the internet, and Nino would say, I knew that, good point. See, I don't think that's really valid, to my mind, because it doesn't matter. Because the internet is a technology. It's the freedom of press, as far as I'm concerned, right? That's how I deal with it. To my mind, freedom of press means literally the physical device, literally the physical printing press, literally the right to fundamentally use the literal physical printing press. That's what it's talking about. So freedom of speech is what you say. Freedom of press is your methodologies for distributing the speech. So the freedom of press literally protects your right to distribute the speech, literally by the press, but also by anything else that would qualify in a more modern sense. And so the internet can very reasonably just be thought of as a slightly more complicated press. I mean, what does the physical printing press do? It allows words to be put into some kind of medium, and the medium to be distributed, and then can be read by the end user on that medium. So if you think about that way, then, you know, this website qualifies. It's text that's been embodied on a medium, transmitted and received by the intended user in the medium, and then it's read. So it's the press. The website is the printing press. It's just slightly different than it was before. But the technology doesn't fundamentally change what it is. You know, in a sort of philosophical sense, maybe, perhaps. So, George Washington not knowing about the internet isn't a problem, because I'm like, well, what is the internet? Well, it's just a method of, at least in part, not completely, but at least in part, it's a method of distributing speech, which seems like press to me. So that's, you know, how I go about that. And he would say the method, which I think is traditional, involves purpose, consequence, values, and something much more, he'd say it's too complicated. Maybe you're the only one who can do it. I don't think complicated is exactly the right way to think about it. I think it's just too open to the die bump. I mean, it's obviously more complicated because you're looking at a lot more things. But because they're looking at a lot more things, it's very hard to imagine how you can do it in a truly intellectually consistent way. Because there's so many strings you can pull at any time. The temptation to justify pulling a particular string just becomes too much. And the problem is you can sort of justify it in the instance. The problem is that you're just not consistent. So it's again like taking the tools out of the toolbox when I want to and leaving them in when I don't want to. You know, it's not just applying the same tool to the same problem every time. It's picking and choosing which tool to use depending on what answer I want, and not using them if it doesn't get me one answer I want. So complicated is one way of looking at it. I'd say just also more susceptible to user bias and user want. And I would say to him, yes, but we have adopted your method of interpreting the Constitution or the statute. We'll have a Constitution that no one wants. I don't know about that. I mean, I think it's doing okay. Because the world does change. Not necessarily so much in terms of values, which, again, when it comes to the Constitution was kind of the point. But certainly in terms of the facts to which those values are applied, which the conservatives don't have any problem with. Because we can just go to the value. We can go to the values. So the facts can just be applied to the values because the values are fixed. So the internet doesn't change anything any more than the telephone or the television or the wire, telegram. Any of these many methods of communication doesn't really change the thing. I'm like, oh, what's the telegram? Oh, it's the press. Well, okay, what's the radio? Oh, it's the press. All right, what's the television? Oh, it's the press. Okay, what's the internet? Oh, it's the press. It's like, I recognize this thing. This looks suspiciously like a method of taking the message from the speaker and distributing it in some kind of medium that can then be received by the user and understood by them. Oh, it's the press. It's the printing press all the way down. So yeah, the facts are like, oh, it's just the printing press again. Oh, you clever guy, you just changed it again. It's the slightly modern printing press. But we're good, so it's fine. And I think that's the real argument, taking very seriously what they want and saying, through example, not through theory, that law professors just made up, but through example, showing that textualism or originalism won't work. I think it does work. The majority thought in Dobbs would be there are fewer cases. We'll turn abortion matters over to the states, and they'll legislate, or Congress will legislate, and they won't be decided by courts. That's what they wrote. That's what they thought. But Tuesday, there will be cases on abortion in the Supreme Court. Well, yes, a different one, dealing with a different issue. But, fine. Many states now have different abortion laws. I suspect many of them will be decided in the court where the words matter, where it will be more complicated than ever. If you think it's simpler, I have a bridge in New York I'd like to sell you. I don't know. I think it's mostly simpler. It's up to the states to decide, and the federal government, doesn't have a right on this. And then you come up with, well, okay, we're distributing a pill across state lines. It's like, okay, well, we'll go argue about that one for a while. But again, simplicity wasn't necessarily the point. It's a bonus, but it wasn't necessarily the point. I thought it was very fitting. The first case you discussed at length in the book was FDA versus Brown and Williamson, which is a seminal case of statutory interpretation, but also administrative law, which is one of your longtime areas of expertise. Can you talk about how you think originalists and textualists generally approach the administrative state and institutional authority of federal agencies? Where do you think they right, or where do you get it wrong? Well, if we're talking about the administrative state, we're really talking about a major change that occurred the way the Supreme Court approached cases in the New Deal. In large part, that's correct. Before the New Deal, there was a tendency to read the Constitution as emphasizing the protection of property and protecting contract. That was the what do they call it? They call it a particular era where it was really heavy constitutional law. The Lochner era. So yes, before the New Deal was the Lochner era, which emphasized the importance of contract and the ability to contract as a prime value. And those were important, but not protecting wages and not protecting the hours of work. There was a long history of cases then, and then the New Deal changed. I mean, that's factually correct. So before the New Deal and the change of legal interpretation, there was all about the principle of contract. And you can agree to anything by contract. So minimum wage laws were illegal by the Supreme Court during the Lochner era because they interfered with the ability of contract, and the ability of contract was more important. So yeah, that was the Lochner era. And then it got replaced by the New Deal era, which changed the law pretty substantially on this issue. Power flowed to the administrative agency, and there was a tendency to allow Congress greater leeway in trying to pass laws that would help implement the New Deal. Fair, that's true. Now why? Well, mostly because Roosevelt threatened to pack the court, and then we had the stitch in time that saved 9, as they say. So mostly because Roosevelt blackmailed the Supreme Court, but I digress. Now why? I'm interested because I want to make the point. And the point is I want to make judges are not deciding things on the basis of politics. Very slightly, but that's not the point. True. Well, what are they doing? Paul Freund, who's a great law professor, put it this way. He said, no decent judge will decide a case on the basis of the political temperature of the J, but all judges are influenced by the climate of the era. I mean, fair. That's true. Because the Supreme Court does need some buy-in at some level, because they have no power to enforce their own decisions. So people buying into what they do is important, and it's for this reason, at least in part, that a conservative approach occasionally requires a more moderate approach, because we don't want everyone to completely freak out. So, in the early 1990s, we had a climate where the growth and prosperity of the United States through new inventions, through new means of finance, had been extraordinary. We changed from one of the poorest to one of the richest countries in the world. Well, I don't know that's quite fair, but, fine. And the court thought laissez-faire economics and property protection, property contracts had a lot to do with it. So isn't implying, in the early 1900s. I'm sorry, I misread that. You are correct, in the early 1900s. I'm sorry. Yes, that's correct. I misread that early 20th century. I'm like, I don't think that's right. In the early 1900s, that's correct. You're right. So we had a very laissez-faire Lochner era philosophy for a while. But at the time of the New Deal, no one or hardly anyone thought that laissez-faire economics would alone save the problem facing the country, which had 24% unemployment, which had terrible depression, where people were willing to give up on democracy, lots of them. And the court changed with FDR and the New Deal. It allowed, for example, legislation to pass laws that would protect wages and would protect against too many working hours. Things do change. True. Yes. Fair. But a change in direction of textualism, originalism isn't going to do that, isn't going to work. Well, yes, but the change is more principled. Again, the change is more principled. Like the change in FDR and the Supreme Court was because FDR threatened to pack the court. And then you had the stitch in time to save 9. The Supreme Court's like, okay, well, to prevent you from completely destroying the institution, we'll kind of give you what you want because you have so much political power right now. And so kind of save their asses to a lot of degree. They gave FDR a lot more of what they wanted, possibly to the detriment of the country to some degree, but that's what happened. So textualism, originalism is trying to restore a principled basis, right? It is not based on the whims of the moment. It's trying to look for a root principle idea that is independent of the facts of the moment. It's looking for an underlying philosophy that can be applied in a consistent way. Look at Dobbs. Dobbs is a case where I dissented. Justice Kagan dissented, Justice Sotomayor dissented. We all wrote one dissent. We thought it was wrong for many reasons to overturn Roe and overturn Casey versus Planned Parenthood, the follow-on case to Roe. And we listed a large number of reasons. Now, one of the reasons is that there's a principle called stare decisis. And stare decisis means that you are very reluctant as a judge to overturn a case that's been decided in the past. Not never, but rarely. That keeps stability in law. Fair enough. That is a principle in law. I agree. All right, Mr. Originalist, now tell me, what cases are you going to overrule? Are you going to overrule all cases that don't use the originalist method? If so, you'll overrule virtually every case of the Supreme Court. I don't know that that's true, because they didn't use that method. They may not have used the method, but many of them got to the right result anyway. So you don't necessarily have to overturn them, because if they got to the right answer, you don't have to overturn it just because they used the wrong method to get there. All right, so which ones will you overrule? Those that don't use textualist or original methods are also very, very wrong. You're coming closer. Well, which ones are they? I mean, that's a fair criticism. That's a fair criticism. The conservatives on the court do not right now have a consistent answer to that in principle. So how do they decide which ones to overrule and how they decide which ones not to overrule is a little bit more pick your poison. But at least to the extent they're overruling them in the correct direction. So, because they're applying them in a consistent way. Now, stare decisis is also a principle, and the conservatives believe that because they're conservative. And one of the things that denotes a conservative is that they're, conservative on change. The conservatives like to maintain the status quo. It's like a central aspect of conservatives. They are a little bit concerned about upending everything. Things are moving along in a, reasonable way. So we should, change with some modesty instead of just blowing everything up, because when you do that, it has a tendency of going wrong. The number of ways for things to go wrong exceeds the number of ways for them to go right. So let's, proceed with a little humility and trepidation overall. But yeah, so the conservatives don't really have a good answer to this about which cases should you overrule and which shouldn't you. And no one right now is willing to say, well, screw stare decisis, which incidentally, I'm not even sure a conservative could really fundamentally do, because stare decisis is part of the common law, which is baked into the Constitution too. It infuses the Constitution. So it'll be a little bit hard to say screw stare decisis, because the entire thing is built on common law tradition, which includes stare decisis. But the conservatives don't have a great answer for which ones to overrule and which ones don't. I guess, yeah, if it's really, really wrong, well, how do you know? Well, I don't know. We just vote on it, I guess. It's a little unsatisfying as a principled answer. I agree with him. The conservatives don't have a good principled answer on this. Incidentally, neither does the other side, though. Although their principled answer is, when it reflects the best interest of the people, I suppose. So their view is the left-leaning metric is, does it, do what I want? Maybe. So I'm not sure the left really has a good principled answer for when to overrule stare decisis either. So I think we're kind of in the same boat on that one, but okay. Now, the reason I get to ask that is who gets to decide? The judges who want to overrule it, and how will they decide? Textualism won't tell that. Originalism won't tell you that. He'll have to think to himself, is this egregiously wrong? He's not wrong. He's not wrong. Now, what have I just done? I've created room for judges to substitute his own views of what's egregiously wrong, or what's really wrong and what's right for the law. Except exactly the thing he adopted textualism to avoid, because they thought the pragmatics, the textualists do that. Well, if they can do that, so can we, so can he, because textualism allows them to do the same thing. Well, it's not exactly correct, although I understand his point, but I think he's being a little bit unfair by half. Because the issue is when to overturn a old decision in favor of a textualist or originalist principle. That's the problem. So if the textualist doesn't do it, they're favoring stare decisis. If they do it, they're favoring textualism and originalism. So they have a tension between the two. And it's true that neither textualism nor originalism really gets you there. So you have this problem of this tension. But if you leave it in place, you're leaving it in place because, well, the juice isn't worth the squeeze, which is a bit unsatisfying. But every time you choose to overrule it, you're always choosing to overrule it in the favor of textualism. So if textualism wins the day, then you're winning that argument. And, fair enough. So he's correct that there's a tension in the philosophy that leaves when to do it a little bit open to the eye of the beholder, which isn't ideal because you love a principled reason to do it. And really the only principled reason you can do it is let's overturn everything inconsistent, which isn't everything, but it's a lot of things. But maybe that's the right answer. You can honestly have that discussion. But anything short of that's like, well, we'll know it when we see it, which isn't great, but what else you got? It's all we have right now. So he has a point here, but I think only half a point, to be honest. Now, on the two promises, clarity, simplicity, definitiveness, and on the other hand, that's three promises, but whatever, keeping judges from substituting their own view for what the law of textualism is as bad. Well, no, I don't think that's correct. Because they're not just, the only thing they're doing is maintaining the status quo. All right? So it's either do I maintain the status quo or do I change it in favor of a more originalist model? So it just doesn't allow them to do anything willy-nilly. It certainly doesn't allow them to change their own, to just adopt whatever viewpoint they have, because either it's like, well, I'm stuck with what I had, or I do this thing that the Constitution demands, right? But in neither sense is it really their view. Now, I suppose it's their view about which is more important in the moment, but so far we haven't been able to figure out how to resolve that tension, and the left certainly hasn't, at least in my mind. Those promises are broken. I wouldn't agree to that. It's just that there's a problem that they haven't solved yet. And you're correct to note the tension, but I think that saying that originalism is pointless because the tension just goes too far. It's like you have a tension between two competing principles, but at least they're competing principles. So, I mean, there's something there, and it's not just a grab bag of principles, because you're only fighting between the two now. Right, so rather than just being able to pull anything from the bag, you can pull one or two things from the bag. And which one you're pulling is a little bit arbitrary maybe, but at least you're making a less arbitrary choice because, well, there's only two things in the bag, so that's nice. And worse than that, we go back to a system where the values of the Constitution or the purpose of the new law will have a harder time taking effect. I mean... No, only one of those things. I mean, that's sort of the problem, Justice Breyer. It's like you got to pick between those two, or at least that's what the conservatives have picked, right? You have a system where the values of the Constitution or the purposes of the law will have a much harder time taking effect. Well, actually, as between that's sort of one of the things that has defined the left-right divide on the court, at least in part, because the left is more in favor of policy as an interpretive tool, perhaps to the point where they think policy is almost definitive in some cases. And so in a system where you have the values of the Constitution versus the purposes of new law, they're going to favor, all things being equal, the purposes of the new law. Whereas the conservatives, all things being equal, are going to value the values of the Constitution because they think that's the point of the Constitution. So I'm not sure that you're back to a system where both those things are harder to take effect. You're back to a system where, you're trying to uphold the values of the Constitution and also uphold the common law tradition at the same time. So there's that, but I don't think that that's quite the right way to phrase it. The person interviewed says, you argue at length in the book that originalists and textualists have no real answer to the question of how they're prepared to apply stare decisis. I tend to agree. I think that's fair. as you say, they seem to have an approach that allows them to substitute their own view for that of other bodies. At least in that respect, yes. I think there's a parallel in their handling of the delegation to the administrative agencies and the decision of those administrative agencies. There seems to be a fairly serious vein of skepticism among judges about the experience and expertise of these agencies, including agencies like the FDA. Well, more to the point, what they've been empowered to do would be the whole thing about Chevron, what they've actually been empowered to do by Congress. So, also, I don't think that Breyer has a principled answer on when to overturn stare decisis, when to apply stare decisis. So stare decisis is just as much a problem for him as it is for anyone else, as far as I'm aware. I don't think he has a principled answer for when to overturn stare decisis. I think stare decisis is just another tool in his tool bag, so he pulls from it as needed. So he doesn't know when to apply it or not, except by when he wants to. So I think it's slightly unfair to say, well, the conservatives have tried to reduce the number of tools in the tool bag. They've tried to reduce it down, and they've gotten it down to a much smaller number. The textualism / originalist approach, and maybe stare decisis, and maybe there's a couple things other in there too. But they've tried to narrow down the tools in the tool bag so that, it's not so much dealer's choice. And you haven't solved the problem either, so, it's a little bit pot calling the kettle black. So, I don't know, it's a little unfair. Just as Breyer says, I think the question of how much power federal agencies ought to have, how much they ought to be listened to, is not really textualist originalist. I would disagree. The Constitution itself says how to make a law. I'm just a bill, only a bill, sitting here in Capitol Hill. Well, right? So the textualist originalist approach says, okay, did Congress pass a law? Cool. What does it say? And then you go apply originalism, textualism to the law. The same way you do the Constitution, as far as I'm concerned. I don't see the difference. The person interviewing thinks there's a difference. I don't think there is. I'm just like, okay, let's go the originalist textualist approach on the statute now too. What does it give the power of the FDA to do? Or the DEA or anyone else? And if it gives them power, cool. Because Congress said it does. And if not, then, cool, because Congress said it didn't. And, so I disagree that it's not a textualist originalist approach. I disagree. And, yeah. And it's the idea of overturning Chevron is the idea that the administrative agencies are limited by their grant of power. They can't do more than Congress said they can do. If they can do it, then fine. If not, they can't, then fine. The words of the Constitution are used to refer to this normally are the word legislative in Article 1, executive in Article 2, and judicial in Article 3. Those words don't explain themselves, and I'm not sure the textualists think they do. Okay, I don't know what your point is, but fine. Rather, they're thinking of a variety of reasons, perhaps, of why there should be less centralized power in the agency or more, and that's a big question. Well, again, I think from the conservative point of view, it's not really whether the agency should have more or less power. That's not the question. The question is, how much power did Congress give them? A conservative, at least in my mind, would not say, well, it's a good thing or a bad thing. This agency has this much power. They'd simply say, did Congress give them this much power? And let that be. And it's up to Congress to decide how much power they have or not. The FDA and the DEA, and for that matter, the entire goddamn military, is a creature of Congress's creation. It's up to Congress to decide, hey, should we have a military? Would that be a good idea? Maybe we should have a military. Hey, what kind of rules should there be for the military? Okay, here's some rules. Hey, what kind of things can the military not do? Now, here's some things the military can't do. That's not good. You can't do that. I order you to do this. Well, you can't order me to do that, superior officer, because, there's an act of Congress. Damn that Congress. I would have gone away with it if it wasn't for these meddling kids. I'm all super thrilled over here, commanding officer. You gave me that order, but, not so much because, provision, blah, 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 whatever, blah, blah. It's like the thing. Or if they can give you the order, it's like, yeah, I can give you that order because it's what Congress allowed me to do. It's like, I don't know how complicated this is, but, fair. Let's talk a little bit about the actual use of history by originalists. Your book focuses on two well-known cases from your last term on the court, wherein you and other dissenters had very sharp disputes with the originalists in the majority. Bruin, which held the Second Amendment guaranteed the right to a pistol in public. No, it didn't. Well, no, it didn't. But, okay. And Dobbs, which overturned Roe versus Wade and held that there's no federal constitutional right to an abortion. In both those cases, there were very serious arguments about the historical record and about whether those records actually support the majority description of American law and society at the founding of the time. You and your colleagues in the minority argued that both those cases should be decided differently, even under the originalist methodology. Now, when people see and hear that, I think it's tempting for them to think originalism is perhaps just a stalking horse for the policy preferences of political conservatives in American society, since they're already skeptical of governmental power in different forms of political, social, and cultural politics. How would you respond? Well, history is messy, and trying to decide what the history says can be challenging, but it is still the North Star, because, like, what did it mean? And, there's reasons to criticize this on a number of levels, but at least you're playing the right game. I have no doubt that many of those who read the cases see something like you said, but it's not a judicial reaction. The judicial reaction, by and large, I admit nothing is perfect here, but in my experiences, they try to get the case right. And they use their approach not as a stalking horse, they use it because they think they're right. I appreciate that. Much credit. I appreciate that you think we're trying to do the right thing. I think we'll get further by understanding and presuming good faith on the other side and deciding on the merits. Well, that's a nice, refreshing change of pace, I'll say that. I think we'll get much further towards a workable and political system, practical judicial system that implements the constitutional basic values, democracy, human rights, a degree of equality, rule of law, and proposes that Congress is trying to achieve in statutes by taking the arguments on the merits and dealing with them, then presuming by bad faith on the part of the argument you could disagree with. Well, that's nice. At least he's willing to say the conservatives are doing it in good faith. For all the challenges of actually doing it, they're trying to apply their principles. It can be challenging sometimes to apply the principle in reality, but you have the North Star, because it's sometimes the record doesn't give you what you want, or the history doesn't tell you as much as you want, or the history is a little bit more ambiguous sometimes. But they're trying. They're trying. You write that the court needs public support, and you argue originalists will find it difficult to maintain informed support for their approach. It would help if the media wasn't, so batshit insane. Then the people might be better informed. How do you think we should determine whether the court has public support, and how do you think they have it now? On public support, I'm making a rather abstract argument, but I think it's an important argument. What I worry is this. Over time, if I'm right, and I think I am, about how originalism and textualism works, they will move, as you say, at the beginning, they'll move towards interpretation of statutes away from the direction of trying to help people. No, I don't think that's fair. They will read the statutes in the interpretation that the statute should be read. If it helps people, then great. It's not about that might be the consequence in principle, that it's more often the case, although I don't know if that's true, but he would have a better insight. So maybe it's true that if you apply originalism, you'll interpret statutes away from trying to help people, but if that's what the statute says, it's what it says. So you're just trying to do what the statute told you to do in the first place. So if the statute's like you're not supposed to help people, then that's what the statute says. So the not helping people is because that's what the statute commands. Get a better statute, I think. So I'm not sure whether or not that's true in balance. He would have a better sense, but perhaps that's what you're supposed to do. They'll move a law from the direction of trying to produce a society where 340 or 330 or 320 million people of every race, religion, every point of view can live together more peacefully and productively. I don't know. I think it's about the rule of law rather than those abstract goals. It's sort of the idea. With guns, we'll be looking at the meaning of medieval terms. To some extent, true, but more recent legislation and commentary, and when I say recent to the time of the adoption, will be more informative. So yes, it is a history of thing, because we're talking about the right to keep and bear arms, which has a long history and tradition. So yes, you may very well be looking towards medieval times, at least in part, because that was part of what they were talking about, because it's a long history. Although more things that are more relevant to the contemporary period of the Constitution will be more relevant. But that's what it's supposed to be, because it's the right to keep and bear arms, which is informed at least in part what happened during medieval times. Remember, the law started in 1189, don't you know? So anything after 1189 is fair game. That's not even a joke, by the way. The British legislature passed a law that defined time immemorial. Time immemorial began in 1189. The more you know. That will move us away from the Constitution basic values, and if we're moved away to that degree, people will instinctively have less reason to follow cases they don't like, which is called the rule of law. Well, I don't know if that's called the rule of law or not. Whether or not people like them, I'm not sure, is what defines the rule of law. The Chief Justice of Ghana, when she asked me if you want more civil rights in Ghana, said, why do you people, you do what you say on the court as a judge? If you don't like where we are, you don't like Bush versus Gore, I dissented in Bush versus Gore, well, you might think, let's have a few riots, let's have a few stones thrown. Well, that does seem to be more indicative of the left all the rest of the day. Is B opposed to both textualism and originalism? Yes. Well, opposed to might not be quite the right framing. As I said earlier, originalism is a label for sort of a group of things, and textualism is a thing unto itself. So when we talk about textualism, when we talk about statutory interpretation, or for my money, constitutional interpretation or rule interpretation, when we're talking about interpretation of law, there are a couple master tools we use that are a couple master tools. So one of those tools is text. So that's a tool unto itself. Then we have the intent. What was it trying to do? We have the history. How did we get here? We have the we have policy. You know, what is the overall arcing goal? We have you know, the precedent. You know, what was the things that were happening in the past, which is kind of history. So we have these sort of, you know, the precedent of statutes or the precedent of the common law, because common law is a thing unto itself. So you have intent, you have the intent or purpose, you have the precedent, you have the history, and you have policy. So these are sort of your master interpretation tools. Textualism, as the name implies, looks to textualism as the dominant, if not dispositive, tool. So it's like, here are 5 tools I could choose from. I like textualism, and I like textualism to the point I'm going to ignore all other tools. I have a hammer, and every problem is a nail. You know, that's a bit of an overstatement, but textualism leans much more dominantly on textualism as a tool. That's the point. Originalism uses textualism in more of a balance, and the nature of the balance gets a little bit tricky, but uses it more in the balance along with the history of it and the precedent of it and to a lesser degree the purpose. So the text of it, the history of it, and the precedent of it are kept in, for the purposes of this exercise, a roughly equal balance, and of a lesser station is the purpose. And the originalists basically completely throw out policy. So they have that sort of balance. And then the left-leaning part of the court has pretty much all these tools, and they tend to discount text they tend to discount text. So if you're thinking about how do I rate these tools, and sort of most important to least important, the left-leaning members of the court are more likely to put text at or near the bottom, in the same way that the conservatives are more likely to put policy at or near the bottom. So in the ranking of which of these tools is best tool, textualism gets reduced down. The left-leaning members of the court tend to think much more in terms of policy as a dominant tool. So policy goes from being thrown away completely to being a tool that is now a primary tool and perhaps a dominant tool and perhaps a dispositive tool, right? So it goes from garbage to, yay, I like. You know, that's the most major change, and purpose also behind it. Whereas the conservative puts it at or near the bottom, the left puts it at or near the top. And so that's the distinction, if you like. It's how those tools are rated, and which tools you like and which tools you discard is the approach. So the textualists, the textualist is willing to kind of throw everything out except the text. So it's like one tool, best tool. The originalist is like, okay, I like these three tools, to a lesser degree this other tool, and to an extremely lesser degree this fifth tool. And the left-leaning members of the court, to some degree, flip originalism on its head. They basically do it to some degree in the opposite order of importance. Yeah, so that's how he thinks. So it's more about the goal. It's like, what is this law trying to do rather than what is it doing? It's like, what is the purpose of this rather than what it says, right? What are they really trying to do with this thing? And we're going to affect what they're really trying to do. We're going to affect the purpose rather than the text. So I don't know if that answers your question, but I hope it does. So really, turn on the television set. We'll see things how work out in cases to decide their disputes their way, and maybe you won't want it. Well, maybe you should tell that to the more left-leaning elements with their summer of love, but I digress. Yeah, Congress isn't all lawyers. They're mostly lawyers, but not all lawyers. There are non-lawyers in Congress. That requires continuity, continuous doing, because you ask them to accept something that sometimes they don't like. And it's not until you do that successfully you have the rule of law. And why have it? That I rather like my favorite author, Albert Camus. Wow. Well, that explains a lot. That explains a lot. Your favorite author is Albert Camus? That explains a lot. Damn. Said about World War II, and we talked about the plague in Algeria, but he's really talking about the Nazis in France. And what he said about the plague, he says the plague germ, it never dies. It lurks in the hallways, it lurks to the attics, it lurks in the basement, it lurks to one day to emerge. And for the education of mankind, it once again senses rats into one happy city. I don't know what we're talking about right now. I'm confused. The rule of law is one weapon over many thousands of years that people have developed to fight the plague germ that lurks in every human being. What? To not be Nazis? I've lost the metaphor. And boy, have we seen it. We've seen it recently. We've seen in ways that convinced us ever more that we have to use every weapon we have, and certainly rule of law is an important weapon in battle. Do you see how I'm thinking abstractly? Yes, I do. Too abstractly for my taste. Which is part of the reason I don't like you as a jurist. I mean, you kind of, yeah. But I think there's considerable realism in that. I don't 100% know what you're talking about. I'm not 100% sure what you're talking about. I'm confused. Let me turn to what's admittedly a very crude measure of support. Public approval according to public opinion polls. The court's public opinion has been struck near historic lows for nearly 2.5 years now. We did a poll recently on a very high profile case before the court, and I was struck by the results. Less than a quarter of respondents say they trust the Supreme Court to issue a fair and nonpartisan ruling. Again, the media is not helping on this. They could please stop, sabotaging the court at every turn would be great. The issue of whether Donald Trump should be absolutely immune from federal prosecution case pending. But I found the results very disturbing. I don't understand how it's sustainable. It seems to me like the mood of the public, or at least a sizable contingent, is deeply concerned with the trajectory of the court. The most I can contribute to that, now that I've retired and thought about this, is to write a book on why the traditional methods of interpretation will work better. Which means that whether or not the president should have immunity is more subject to the popular whim rather than a legal principle, which is not great. I just wish people who are not lawyers might read it. Of course, every author would like that. But read it and see how it experiences, not theory of law school, but experiences led me to think it's an important problem in the area you're talking about. Your book argues that originalism and textualism may eventually produce their own demise. That over time it will become apparent as you write the strict versions of textualism and originalism simply will not work. Well, maybe, but if that comes to pass, then it will get adjusted. Like anything, right? So you have an idea in mind. It's like, I have a principle. I have a principle, and I'm going to try to run it into the ground. And if you reach a conflict, then what you do, at least if you're me, is you try to rethink everything from first principles. Because it's like, well, you know, I've reached a problem where I can't do what I was trying to do anymore. So I need to rethink everything so I can try to find a new path that hopefully allows me to do everything in a consistent way, as opposed to just doing arbitrary things, which is not ideal. So will strict textualism and originalism simply not work in the end? I don't see that, but then again, I don't claim to be able to foresee the future that well. It may be the case, but if that is the case, if that's what experience proves, then the people who believe in it will be forced to try to revise it with something else that will be better in a consistent philosophical way, ideally. But, you know, we can deal with that when we cross it. I can't see it right now, so I can't prevent it in advance because I can't see it. So it's like, well, since I can't see it, I'll do what I'm doing, and if I ever get there, I'll let you know, and we'll try to do something else. But it's a good tool for the moment. It seems to answer every question at the moment. It seems to be a universal tool. Will it stand the test of time? Who knows, but we're going to try. I think it's very intriguing because the sort of theory of natural or organic decline, but as you acknowledge, there's no way to predict the future with certainty. And even if you're right, there's no way to know how long it will take. For many people, particularly after Dobbs, their concerns about the jurisprudence of the court are more urgent and more worthy of aggressive solutions now. I mean, they could just vote for abortion. I mean, you know, there's that. In the past, you've expressed openness to the idea of term limits, but you warned against adding more seats. What is your current thinking? The one I've talked about for many years is term limits. Many other countries do that. Canada does, England does, and it would have to be long because you don't want the person in the court thinking about what's next job it's going to be after retiring, but it will alleviate the pressure, which is personal and comes from the condition we all have, which is called mortality, where you decide what the right moment is and so forth. Those are different personal decisions. And so I haven't been against that. I haven't been the notion of having a long fixed term for a Supreme Court justice. Whether it's a major fix is not clear to me, because the major fix and what I am driving at is exactly what John Ahmes thought was the only way of government by the people. It's a government of democracy and protection of human rights. Will it work? It's an experiment. I mean, I'm not necessarily opposed to term limits if we implemented them in some sort of staggered fashion. You know, maybe we could have 18-year terms, and then the president of the United States would, for example, always appoint a Supreme Court justice on an odd number year. Maybe that's the way to solve it, right? They'd always appoint a person in their, like, you know, maybe the end of their first year, like the beginning of their second year, the beginning of the fourth year, maybe something like that. Maybe that's the way to solve it. You know, so maybe that's the solution. You know, they make the appointment as of January 1st of, you know, every even year or something. I don't know. But I'm not necessarily opposed to that as long as we stagger it out, you know, so that it's, you know, staggered, which would allow it to not be, you know, which is a principled solution, because I don't know who's going to be the president in the future. So it's an interesting idea. So maybe, but you know, of course it would take a constitutional amendment, so you're going to take a lot of buy-in, but maybe. A lot of Americans say right now that they are worried about the future of American democracy. Are you? Senator Ted Kennedy used to say the country swings first one way, then another. Winston Churchill used to say the country always does the right thing after trying everything else. Cute. We go back and forth. We survived all kinds of things. We've survived the Civil War. We survived Vietnam. Look at Bobby Kennedy talking in Indianapolis the day after Martin Luther King was assassinated, talking about Achilles, talking about the pain, talking about why we must act as one nation and stick together. Only a few years before his brother had been assassinated, and only a few weeks after, he would be assassinated. A number of students at Kent were killed during the era. Watts had been burned, and people were talking about burning parts of Washington. I started teaching then. It was very difficult indeed, and we survived. And of course, the Civil War was incredible, very bad, and slavery. What do you think of that? I think slavery is probably bad. And Jim Crow. Read W.E.B. Du Bois. You will see the country's been through a lot. I tend to agree. But as I learned in the 5th grade, that people in the country are pretty good at getting their act together and helping each other. And we saw that in Cambridge during COVID, when groups got together to see if old people had enough to eat, and we're all right. And that happened not just in Cambridge, but all over the country. There are pros and cons in America, and so far we've risen to the occasion, so naturally on balance, I'm optimistic. Okay, well, you know, fair enough. That makes sense. That makes sense. So I you know, obviously I don't think he's right, but I might buy his book and read it just because it might be interesting to critique it in more depth. So maybe we'll have a book report. We'll take notes or something. Could be fun. So I'll answer any questions you have as I wrap this up. So are there any questions I didn't answer along the way that I can try to clarify something or speak to some of these issues? I'll give you a second to type. And by the way, happy Easter for everyone out there. I hope you're having a great day. Any questions at all? Ben Candy? Can't help you out, man. Uber Eats, maybe. Maybe you can get some, you can, how am I doing? I'm doing pretty good. I had a nice breakfast with Nate the lawyer. Nate the lawyer called me this morning. Is like, do you want to go to IHOP? I'm like, sure. So I had a nice meal with him at IHOP. And then tomorrow, presumably, we're getting together to work out again, I think. That'd be nice. Great. Nate's a cool guy. Yeah, Nate's the cool guy. We went out and with his daughter and had meal. I had the 2x2x2. I had 2 scrambled eggs with cheese and 2 strips of bacon and 2 blueberry pancakes, double blueberry with blueberry syrup and some coffee. It was good. Nate is pretty tops. Yeah, Nate's a good guy. Am I originalist or textualist? Insofar as there's a difference between the two, I think of myself more as a textualist. I don't know if I'd go as far as Gorsuch, but I found his opinion in Bostock incredibly persuasive. So, Lincolnberry? That's a good choice. Are states currently deciding policy on abortion? Yes. Is it illegal federally? No. Yeah, no, there's no federal law on abortion except maybe the mailing of drugs, but that's the issue we're dealing with right now. So no, it is up to each individual state. Some states allow it, some states don't. Which is the idea of the laboratories of democracy. It'd be interesting to see if someday there's some sort of consensus position. Which, you know, you never got to have the debate because of Roe. You know, if Roe had never happened, it'd be interesting to see what happened on the issue of abortion when the states still had control. And it'd be interesting to see what happened, you know, 50 years later. So I don't know whether or not the states will reach some sort of consensus position along the way. It might take 50 or 100 years, but we'll see. Yeah. It's being enshrined in a lot of states' constitutions, that's true. But of course, those can change. State constitutions are a lot easier to amend than federal ones. So, I mean, the state constitution still has supremacy, but it's not as hard to change. And the reason you know that is because they're putting it in there, which means it's not that hard to change, right? So it's like, yeah. What are my thoughts on the abortion pill? You mean as a matter of the court's decision on the issue? Well, as a matter of the legal decision, I think that the FDA is likely to win. I don't really think that the advocates have standing on the issue. And their standing issues have been completely destroyed in horrible, horrible manner. And I don't even think they have redressability. So my expectation is the Supreme Court is going to overrule the issue and allow the FDA's 2016 and 2021 extensions to go forward. So that would be my expectation. And I think it's going to be unanimous or close to unanimous. It's going to be like 9-0 or 8-1 to reverse in favor of the FDA. What if someone gets an abortion in a legal state? Can they be criminally charged? Oh, sure. Yeah, absolutely. Well, I don't know the answer to that question. In principle, yes. In practice, I don't know. So I don't know the answer to that question as a matter of the various state laws. I don't know. I don't know if any state currently has on the books the method to prosecute the person getting the abortion. I believe to the extent that it's criminal violation, it applies to the doctors, not to the patient. But I couldn't swear to it. But in principle, the states could make it illegal, so a person getting an abortion could be criminally prosecuted. But I don't know if that's happening. So there are 50 states. I can't keep track of them all. If you come to Houston, will I have breakfast with you? I absolutely will, Leslie. If you're single. Single women allowed. All the single ladies. All the single ladies. All the single. Do I ever delve into contract law? I mean, a little bit, as it happens to come up, sure. The ban won't work if they can get the abortion pill in the mail. Well, I think states can ban it. And states would have standing, I think. So I think a state would have standing to say you can't ship the pill into our state because of Dobbs. So it's like, yeah, I think they would have standing to challenge the mailing of it. So yeah, I think that may not survive for the moment, but I think a state could ban it. It's like you're violating our state law and you can't do that. And it's illegal as a matter of state law, and you're violating our laws to stop. So I think that they will be able to ban it from being mailed in the states where it's illegal. Who is liable? I don't know the answer to the question. It would depend, of course, it would depend completely on the state law. It depends completely on the state law. With respect, I don't know who would be liable. You'd have to go consult the exact nature of state law. It's up to the state to determine if it's illegal. And if it's illegal, it's up to the state to determine who the law applies to. I don't know. To the best of my understanding, it applies to the doctors and facilities that prescribe it, but it's going to be state by state. Happy Easter. Happy Easter to you as well. Yeah. States can't ban something like the FDA approves the supremacy clause. Typically, that's true. But I don't think that's true in this particular case. Plus, they have the Volstead Act, the Comstat Act going for them, right? Because the Comstat Act says it's illegal to ship via mail or any common carrier into the state. So if you can't send it into the state, then, there's that. So I don't think that's true in this particular instance. Also, I'm not sure it's generally true, to be honest, because it's up to the states to regulate the practice of medicine. So I don't know for sure, but I think a state can prohibit the FDA. Well, strictly speaking, they're not prohibiting the FDA, they're prohibiting the manufacturer. So the FDA only approves drugs. They don't, I don't think that's right, Matt. I think you can pass a law prohibiting a drug from coming into your state because the state regulates the practice of medicine. The FDA may say what drugs are approved, but the state regulates the practice of medicine. So I think a state can ban any drug, probably. So I'm not sure that's true. Yeah. There are many legal issues coming for sure. There are many legal issues coming for sure. I found me through Natalie Lurchik. You like my politics better, but you're both great. So is Nat. Yeah, Natalie Lurchik's and I's politics are vastly different. But we wind up agreeing a lot on legal interpretation because we're both doing good legal interpretation. So the number of times that we actually disagree is relatively fair and few between. We come at it from completely different legal angles, but I find Natalie Lurchik gives pretty good legal advice or pretty good legal analysis, maybe in spite of herself, but then again, I give advice or analysis in spite of myself sometimes too. So, I think she's fine. in terms of our analysis. I'm trying to remember the last time we had a sharp disagreement on the legal issue, and I'm struggling to think of one off the top of my head. People will resend in the mail? Yes. Courtesy research says folks, of course, have said nope. I don't know. That doesn't sound right, but, you know, whatever. People might resend in the mail. Yeah, people send all kinds of illegal things in the mail. What's your point? People break all kinds of law when they're sending things in the mail. People send drugs in the mail. What's your point? Some famous singer was handing out Plan B pills at their show. Plan B is over the counter now, so that should be fine, I would imagine. So I think that's legal. Anything else? What if that become an abortion charge if someone sent an abortion pill to a Texas resident? Yeah, it could very well be. Could very well be. It could very well be a murder manslaughter charge, for sure. You are facilitating a crime. Yeah, that works. I mean, no problem. Again, it would be up to Texas to do that, but they could in principle, right? I mean, if Texas makes it illegal, then it's illegal. And you're literally sending something into the state for the purpose of an illegal act. So yeah, you would be an accessory to manslaughter, murder, or whatever else it is doing, because you know that's what it's being used for. It's like, so yeah, I mean, yeah. New Oxford American Dictionaries on Kindle, that's cool. Yeah. We'll see what the Supreme Court does with the issue. But yeah, I would imagine that states would be able to ban the medication from their state. At least under the Comstock Act, I would think. But yeah. Okay. Well, I guess I'll sign off for now. That was a fun legal discussion. I hope you learned some things. I learned some things. Everyone had fun. You had fun, right? We all had fun. All right, so I'm going to sign off for now. If you've enjoyed this, please remember to give it a like. I do appreciate if you'd hit the like button. It does help with the algorithm. For a mere 99 cents a month, YouTube can become an uncivilian. It's true. It is literally the cheapest membership on YouTube. And it's on sale right now at 99 cents a month. So if you sign up right now, you get to lock in that 99-cent price as a member. And you get to be a member of the channel, and you get to have access to behind-the-scenes content, off-brand content, gaming streams, other things. I do recording sessions sometimes for other things that I put there on members only. And you get to support the channel. It's nice and fun. So, you know, hit the join button for 99 cents. It'd be great. And, you know, yeah, I'd appreciate it. So I'm going to sign off. Until later, my friends, I hope all's well. Cheers, my friends, and goodbye.